afternoon, depending on what time you get to see this conversation. We call it a courtroom, of course, because we've got attorneys here, we've got CAs who will be deliberating on certain legal and tax matters as an ongoing. So for you to be watching this, it's a great, and we say grateful, we're grateful for that. And we wish you to recommend and also suggest some of the additions and value adds that you think will be beneficial to you. Tonight, as usual, I'm with Lisa Hugo and Bruce Bakhazen, and they will, of course, introduce themselves. Good evening, Bruce. Good evening, Lisa.
Evening, Shelly Boy and Lisa. It's always a pleasure to join you, and also our viewers. I'm always excited about the law. It's a little bit of an obsession. Don't tell anybody.
Good evening, everyone. It's a pleasure to always join you guys every Tuesday evening, and I look forward to recording more sessions for you guys. And yeah.
Yes, of course, it's every Tuesday we try to record something so that we update and empower and educate you who is into wealth and also who's into preserving that particular wealth. Tonight, Bruce, we've got an interesting story, or rather, we've got an interesting case, a study, or a case for that matter, that we want to deliberate on. Do you want to perhaps maybe give us those background facts and also some of, and highlight some of the interesting things that you picked it up from that scenario? And of course, we'll then jump in and have a discussion, the three of us.
Thank you, Shelly Boy. Well, first and foremost, it's a divorce matter. It's actually been in the media of late, where husband and wife were married. They were married in out of community property, but with the accrual. Now, the short and long of what that entails is that what's yours is yours and what's mine is mine. However, whoever estate grows, we share in the growth. And there's a bit of a sum to it, but it's not too complicated. But the gist of it is to try and simulate being married in community of property while minimizing the risk of debtors, creditors, the works. So now, what happened was Mrs. Wifey, unfortunately, fell in love with somebody else. And she wanted a quick, lean, mean divorce. She was in a big hurry to get divorced. She couldn't wait long enough to dive into the arms of her lover, which, and I'm quoting the word lover from the court judgment, believe it or not. So they signed a settlement agreement, which is perfectly normal. And in fact, most attorneys would recommend, you know what, if you're divorcing, try and conclude a settlement agreement. It makes it easier, cheaper, quicker, which is factually the truth. She signed it, but then they got divorced. And a few years later, somebody pointed out that, hey, actually we're entitled to a big chunk of the growth in the estate because the husband's estate grew quite handsomely during the marriage. And suddenly now she felt done in, right? So she went to court and she wanted the court to reverse the settlement agreement. It's very important that you take note there was a settlement agreement. In other words, they agreed how they were going to be divorced and how they're going to share the assets. And they raised a number of interesting arguments. For instance, she did not understand. They used the same lawyer, which was true. And she was somehow cheated out of her cut of the estate. Basically said that, well, you agreed to it. You literally signed it. There's even text messages saying, if you don't sign, I'm going to sue you for what I'm entitled to. So long story short, she wanted a quick, lean, mean divorce, but after the fact, she had a bit of buyer's remorse after realizing she'd been heavily done in. And the court said, not a chance. Sorry. You can't come after the fact and say you feel like you didn't get the right deal. You can't even plead that, no, you're a lady. You can't. Unfortunately, you signed it. You agreed to it. In fact, you did it with full knowledge, as the evidence suggests. So unfortunately, we're not messing around with that court order. It stands, and you're just going to live with the consequences. You are, in fact, the architect of your own circumstances. So in a nutshell, that's the facts. But there are interesting concepts at play here. And I'm going to briefly dive into it. Shilly Boy, please jump in and say, Bruce, you're getting a bit off topic, but I just get excited about the law.
And of course, be mindful that some of us are tax advisors, not really attorneys, and will prefer if you summarize those interesting facts in a layman English.
100%. Well, first and foremost, what was interesting was they got married out of community of property with the accrual. Now, the reason why I say this was interesting is because most people are married in community of property, right? Which would not have actually changed the outcome if you signed a settlement agreement. But here she literally gave up her right and entitlement, which could have had some interesting tax consequences because she was entitled to the accrual and she just gave it up in order to pursue her emotional desires, which I'm not saying is right or wrong. It's just that it was a quick decision to get divorced the way she wanted. So now she was married out of community property with the accrual. She did not go and get independent legal advice. Failure number one on her part. If you're getting divorced, go and seek independent legal advice. I implore you. Otherwise, you are going to be sitting in her position because most lawyers will say, listen, you are entitled to X, Y, and Z. You must understand that you do this knowing that you are literally giving away that which you're entitled to. I've got a case actually at the moment where there's a divorce looming. They were married in community of property for a short period of time. But the wife doesn't want half of the estate. Right? And as a lawyer, I have to point that out that, listen, you're actually giving up on all that, which you're entitled to. You are diminishing your estate. And of course, most tax practitioners and financial planners will say, well, guy, this does not sound right, because there are various tax implications. So now that's the fact that she was married with her accrual. The next, and that she did not get independent legal advice. Another notable and interesting aspect of the case was that she literally sent SMS messages threatening her former husband to sign the papers. Otherwise, if he does not sign the papers, she will sue him for everything that she's entitled to. So, guys, what I'm trying to say is that if you're going to make admissions, don't do it in writing. Do it over the phone. Us lawyers love when things are in writing.
But I mean, these days, phones even automatically record. I mean, you taught me how to record phones. But yeah, anyway, but we're not there. So I think for me, like what you said, it's a quite an interesting case. And you already gave nuggets to say, seek an independent divorce attorney for that matter. And of course, also understand what you are giving up and don't be emotional. We understand divorce can be very, very emotional phase of someone's life, but try to take a step back and say, what am I actually giving away? What am I actually compromising? Is it truly what I want? And you might find that there are kids involved there. And you saying, I don't want anything from this partner of mine. But you find that actually you are compromising you're compromising your kids. And that might not actually be more sustainable for that matter. Of course, also divorce, I think for me, it's a matter of there are tax benefits that divorce actually very strangely present tax planning during that phase. And I think I always encourage people that if you are faced with divorce, also involve or tell your divorce attorney to involve tax advisors to say, okay, maybe we need to do a proper estate planning and more of moving things around. So, and I think that's one of the things, especially when you're going to make settlement agreement a court order, that raises obligations that you can actually leverage that off to move estate across to various investment structures for your betterment of estate duty planning and wealth protection. Do you want to say something, Bruce, before I bring Lisa in? I see that you are agitated and you want to say something.
Funny that you should mention leveraging the court order to increase tax efficiency. Believe it or not, it's also possible to create a trust in terms of a court order.
There we go. Exactly.
Right?
Exactly.
So you can all tie it in one neat, tidy bundle, and it simplifies things incredibly so.
Exactly. So I think I'm going to pause a little, and then we'll obviously the second part will dwell into the technicalities and how everything. If you are still interested. Also, I mean, we obviously going to divide this into two parts. So for those who might have seen the part 2, you're more than welcome to reach out to me, and then I will then share with you the second part. And you can WhatsApp us, you can email us for the second part. But the second part, we're going to be dealing with more the technical side, application, the law side, the content of the agreement, the variations. I saw one, they call it a non-variation clauses. I'll be interested to know from Bruce what those things are. So yes, we're going to pause a little bit and then continue with the second part.